In life, there are some things we don't have control over. One of them is that children cannot be involved in the selectional process of their biological parents. On these issues, we can't sorosoke, as we used to say. Nevertheless, there are still some people that are being referred to as bastards, illegitimate in the society. In Nigeria, however, the concept of legitimacy is very important because of the social stigma that is associated with it, and nobody likes to be referred to as a bastard. Under family law, a child is considered illegitimate if born outside of a valid marriage. It is important to note that the issue associated with illegitimacy is always very heightened during section. Fortunately, this issue doesn't have to be like this. It doesn't pose a problem provided that the deceased died testate, that is, the deceased died with a will. The rationale is that the testator has the right to give any of his or her property to his or her child, or anybody whatsoever, whether the child is born through him or not, as it is the person's will. Firstly, this issue is heightened when the deceased dies intestate, that is, when he dies without a will on how his assets should be distributed. And this problem is further compounded where the paternity of the child is not acknowledged by the deceased before his death, either because he did not know of the existence of the child or for one reason or the other. Section 42 of the Constitution of the Federal Republic of Nigeria 1999, particularly subsection 2, provides that no citizen of Nigeria shall be subject to any disability or deprivation merely by circumstances of his birth. But in order not to use this part of the law as a means of irregularities or unlawful acts, for instance, promoting of promiscuity because they know their offspring cannot be discriminated. However, the court, through many judicial pronouncements, has extended the requirement of legitimization, which includes either acknowledgement by the father or presentation of clear and convincing evidence. Based on this, the court in Okonkwo versus Okonkwo held that by virtue of section 42 of the Constitution of the Federal Republic of Nigeria 1999, children born out of wedlock but whose paternity was acknowledged by the intestate have equal share with the children of the marriage. In essence, the court held in this case that once your paternity has been acknowledged by your father, that he gave birth to you and he recognizes you as one of his offspring, you have the same and equal amount of right to the child to all the children put together that was born in wedlock. Now, what if the father doesn't acknowledge the child? One might think that this is the end of such child, but no, it isn't. The paternity of a child can be established by proofs such as birth certificate, forms, photographs, and other forms of documentary evidences. It is also noteworthy that the paternity of a child can also be proven using scientific tests. This test is also recognized by the Child's Rights Act. Section 63 subsection 1 paragraph A of this act states that in any civil proceeding in which the paternity or maternity of a person falls to be determined by the court hearing the proceeding, the court may, on application by a party to the proceeding, give direction for the use of scientific tests such as DNA to show that a party to the proceeding is or is not the father or mother of that person. In conclusion, the process of providing that paternity of an illegitimate child is cumbersome, particularly where the deceased died intestate. However, once it is proven, the web of stigmatization placed on such an individual will be removed and he or she will be on the same pedestal as the legitimate child, consequently giving him or her the right to partake in the succession process. By now, I believe you understand the rights of illegitimate children within the Nigerian laws and how they can partake in inheritance. This is Official Joel TV. Stay tuned for more educational videos like this and subscribe for more.